Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 148 notices. The issue is that if the reopening of the assessee under section 148 has been done by taking the approval of the Principal Commissioner of Income Tax with the note by the Principal Commissioner of Income Tax that yes, I am satisfied with the reopening of the case, then whether only this remark in the approval given by the Principal Commissioner of Income Tax is a valid approval or not, and whether on this ground the whole proceedings under section 148 read with section 147 can be struck down by the courts. This issue has been taken by Delhi ITAT F bench in the case of RAGHAV Technology Private Limited versus Income Tax Officer, and this case has been reported in 119 ITR Tribunal at page number 1, and the date of the judgment is 30th April 2024. Friends, in the present case, there was search on a person named SK Jain. All we know that SK Jain was a very big entry operator, and during the search it was revealed that various assessees have taken accommodation entries, and on the basis of the statement of SK Jain, the case of the assessee under section 148 was reopened under section 148, and the approval was taken from the Principal Commissioner of Income Tax. In this approval, the learned Principal Commissioner of Income Tax has given the approval by only mentioning that yes, I am satisfied with the reopening of the case of the assessee. The additions were made because, as all we know, that as on date, the situation is that whenever some name of some accommodation entries come in some statement, even if the assessee do not have any relation or any relation, and if assessee submits any document to the satisfaction of the AO, then in the present scenario the situation is like that the assessing officers are not accepting any submissions, and they are just making the additions whatever the submissions the assessee is giving. So in the case also the additions were made. When the matter was brought to the CIT appeal also upheld the order of the learned assessing officer. When the matter was before tribunal, the assessee vehemently pressed this ground that section 151 approval is a safeguard in reopening the assessments under section 147 read with 148, which has been likely taken by both learned assessing officer and Principal Commissioner of Income Tax. When tribunal heard this matter, because the assessee was relying on three very important judgments, two judgments of the Delhi High Court and one judgment of the Delhi ITAT, and even one judgment of the Supreme Court also. First case was Principal CIT versus Pioneer Town Planners Private Limited. This is the case of Delhi High Court. Second case was United Electrical Company Private Limited versus Commissioner of Income Tax. This was also the case of Delhi High Court. And third case was VRC Township Private Limited versus Income Tax Officer. This is decided by Delhi Tribunal. And one Supreme Court judgment is also there on the point that if the approval is given just by saying that yes, I am satisfied, then the whole assessment is bad in law for want of a valid approval. So in the present case, the tribunal also quashed the assessment proceedings just on the ground that the approval is defective. At the same time, the tribunal said that satisfaction has to be recorded of the given case, which can be reflected in the briefest possible manner, and it is not as if the commissioner has to record elaborate reasons for agreeing with noting put up before him. But the satisfaction should be genuine, it should not be mechanical. The tribunal quashed the assessment proceedings on the sole ground, and even the merits of the case were not discussed because the assessments were bad in law for want of a valid approval. At the end of this video, once again I am repeating the name of the case. The name of the case is RAGHAV Technology Private Limited versus Income Tax Officer, and this case has been reported in 119 ITR Tribunal, and the matter has been decided by Delhi Tribunal ITAT F bench, and the date of the judgment is 30th April 2024. Thank you, friends.